No, Your Honor. Prepared for closing argument, Your Honor.
Closing arguments. All right. Let's go for that.
Your Honor, I submit that based upon the testimony presented that the charge of obstructing an officer has been proven beyond a reasonable doubt. The charge involves intentional and physical failure to comply with the officer's order. I believe that the testimony, first of Officer Nieberlein, was important to this case to stopping people on the road. It is because we want to catch people who are driving under the influence of drugs or alcohol. That's clear. It's also, as testified to by Officer Nieberlein, to educate the public. So a lot goes into it. There's, as you can tell from Officer Nieberlein's testimony, there's meetings and cooperation between agencies, all these things that happen in the background before the actual event, before the date of the checkpoint. And as Officer Nieberlein testified, that was done. He personally is responsible for making measurements, determining where signs, warnings go, where the escape route is for somebody who's, in this particular case, driving up Sparks Boulevard towards the checkpoint. So for this checkpoint, Officer Nieberlein did that. He also testified that he was aware, because he was also involved, even though not directly involved with this defendant, involved in the checkpoint and observed, even at the time that the incident was happening, that everything as far as the checkpoint itself was as it should be. Everything was being complied with as far as signage and location and organization. Now, on this particular day, Mr. approaches and enters into the DUI checkpoint. There's no testimony about where he was coming from, but it's clear that he entered the checkpoint and made contact with Deputy Binley, who was one of the greeters. And when Deputy Binley made contact with him, it's clear from the recording, and it's clear that the recording was made by the defendant at the time from inside his vehicle. You could hear his voice speaking about his approach to the checkpoint. And in that recording, you hear Deputy Binley, first very muffled, his voice is very muffled, telling the defendant to roll down his window in order to effect the contact that is appropriate during the stop. And as Officer Nieberlein testified, this is supposed to be a brief to see if there's any drugs or alcohol in it. So, Deputy Binley, first, what he's trained to do, asks the defendant to roll down his window. And it's clear from not only Deputy Binley's testimony, but from the recording that was made at the time, that the defendant either ignored the order by silence, refused, delayed by asking why, what are you doing? He outright was confrontational with stop it, said that several times, and Officer Binley asked him 10 to 20 times to roll down the window before it was rolled down 3 inches. Now, Officer Binley indicated that why he was making observations through the window, what the purpose was. He indicated that he observed red, watery eyes, and there was a fruity smell that he couldn't identify, but something was going on. In addition to that, he indicated, he testified that consistent with his training, there's other behaviors that are looked for to indicate if somebody is an impaired driver. And one of them is repetitive speech, saying the same thing over and over again, and their demeanor. And in this case, there were some indications that something was going on. He had the red watery eyes, there was an odor of something that he believed could be alcohol, and then there was generally the defendant's behavior. So he repeated the order to roll down the window. Now obviously, at some point, he's knocking on the window, he's asking him repeatedly to roll down the window. The contact is taking longer than the normal brief contact that the checkpoint is designed for, and other officers' attention is drawn to the situation. And as you heard in the recording, was testified to by Deputy Binley, and also to Officer Nieberlein, who observed from his position several cars back, I believe, and indicated 7 cars back. I'll defer to the record if I'm wrong about the distance. But he indicated that he could see that something was going on, that officers were all around this vehicle. Now, the officers approaching this vehicle is as a result of the defendant not complying with the lawful order given to him by several times, 10 to 20 times, by Deputy Binley at his first contact with the defendant. Then, as is the nature of things, when a person is not complying, other officers get involved. They're trying to get compliance from a suspect, the defendant in this case, and people are speaking on top of each other. Things like that are happening. But, Your Honor, it's clear at the beginning that Deputy Binley asked the defendant 10 to 20 times to roll down his window, and not only did the defendant not do it, he was refusing to do it. We heard on the recording, the defendant's recording of the incident, what was going on. We heard him say no, we heard him say stop it, we heard him saying nothing, we heard him basically not complying with Deputy Binley's order for quite some time. And Your Honor heard how long that went on for before we heard another officer's voice get involved. Until that other officer got involved, we simply had Deputy Binley issuing an order and the defendant not complying. And it's clear from the recording that he knew what he was doing. I'll submit this to the court that the recording indicates that he was completely aware. The defendant's voice was actually very calm. Even when he was saying that he was afraid, he was very calm. And he was actually, in a calm way, confrontational. He was obstructive. He knew, from the recording, I'll submit this to the court, he knew that he was stonewalling the officer, saying, no, I'm not doing what you want me to do. It's not going to happen. Tell me why. And then there were these periods of silence while the officer was repeating his order. And that was the initial contact. And then, of course, you have other officers that get involved when they see a suspect that's not complying with an officer, a fellow officer, and they approach, they try to persuade, cajole, demand that there be compliance. The defendant still refused to comply. And he didn't roll down his window anymore. Eventually, after several orders, he turns off the car. Then it's more open the door, and he, I'll submit to the court, takes his own sweet time. So the fact that he eventually does it does not negate the fact that he was not complying and he was delaying the officer in his official capacity during the checkpoint. And I believe that is very clear, not just from Deputy Binley's testimony, but even more from the audio recording that is occurring in the defendant's vehicle, because it's being recorded by the defendant. He's approaching the checkpoint, indicates how far from the checkpoint he is, gets into the checkpoint, and then refuses to comply. So based on that, Your Honor, I believe the charges are proven beyond the reasonable doubt.
Your Honor, what we have is 4 to 5 minutes. And what this court has to decide is how much this defendant did not comply. And so let's look at the facts as they were recited by the officer himself. First of all, this case speaks volumes in what this client or this defendant was not charged with. He had a lawful weapon. He was not intoxicated. He knew when he entered that checkpoint. And as you well know, when you enter the checkpoint, you have no choice but to go past many officers that he had a firearm. Now, it said 10 to 20 times that he asked him, but the fact is, if it all happened within 4 to 5 minutes, he could have asked him a couple, 3 times, which is, I believe, what we did here, and I would continue to object to most of the evidence in the tape. But that tells you that there were a couple, 3 times, and by that time, there are 10 officers all telling him different things that he must do. We know that at least one officer told him to shut off his vehicle, which he did immediately. We also know that it's a natural response to make certain that they can see your hands at all times. And the officer testified that yes, he could see his hands, and it was only when he stopped to do something else that he didn't see his hands. And that was after the vehicle was already open. Now, whether or not this takes longer than the officers are instructed to have a DUI stop or have an administrative stop is not the standard by which this must be judged. That's the standards by which they are supposed to make contact. He was asked to roll down his window. He rolled down his window 3 inches. Knowing any further, they would probably see the firearm. He saw many officers there that were armed. What cannot be considered in that tape is any time he asked, well, is this the law, or what is the law, or what are you doing, or can you do that? Because in Ramit versus State, the state of Nevada, the Supreme Court of Nevada determined that you cannot use as evidence against anyone the fact that they inquired about their constitutional rights, or it cannot be used as evidence of guilt that they were trying to express those rights. Now, when the city attorney says they cajoled him, Your Honor, they threatened to break his window if he didn't open it. I would say that's a step beyond cajoling. Here's what he complied with. They told him to roll down his window. He rolled down his window, and obviously they could clearly speak with him because you could hear it. They asked him to turn off his vehicle, and he did. They asked him to unlock the vehicle, and he did. They asked him to exit the vehicle, but by that time they had hands on him. He was leaned forward with his hands handcuffed behind him and could not himself remove himself from the vehicle. There were 10 armed police officers versus 1. That's what this is about.
Check your arm.
He
That's
did-
not an evidence.
Oh,
What's
it's
not an evidence?
Documentation.
What's not an evidence?
The occupation.
In that limited sense, the objection is sustained. I think it's largely irrelevant. Go ahead, Ms.
And just because he had with him a lawful weapon for which he had a permit, he was in fear of his life.
I'm going to object to
If-
that. That's not an evidence as well. I'm sorry, but I'm going to object to that.
Well, I think there's enough testimony to support that as a matter of argument, maybe not as a matter of fact. The objection is overruled.
And finally, Your Honor, as I have briefed, the defense of self is an absolute defense in this situation, because knowing what goes on in the world today, if you're surrounded by 10 armed police officers issuing instructions to you when you are in a position you cannot escape, and you know their fear, and as the officer admitted, his concern is for his safety. The defendant's concern was for his own safety. The longer he waited to try to figure out what to do to make certain that he did not unduly alarm these police officers, to make certain that he was safe. That is what this is, and that is defense of self. And that is what happened here. In the 4 to 5 minutes that this occurred, this defendant acted in defense of himself because he knew he had a weapon, a firearm, on his person. There's insufficient evidence to show that intentionally obstructed a police officer. He obeyed the instructions of the officers. It is merely a matter of timing. They say that's not what they expect when they have an administrative stop. That is not the key, and that's not the element, and that's not this court's decision. And Your Honor, I would ask further that the tape be stricken, because we have no idea if anybody created that tape. with editing out all the other instructions that were given to us. We have no idea what that tape was able to pick up. We have no idea who produced that tape. There's no chain of custody before this court about when that tape was recorded, where it was found, and then how it was recorded, and if further editing occurred, because the person who created it is not before you. I would ask that it be stricken completely. Refusal to consent to a warrantless search is privileged conduct, which cannot be considered as evidence of criminal wrongdoing. Your Honor, you must exclude all evidence of his questioning of this warrantless search. I would submit to the court that these charges should be dismissed because this defendant was acting in self-defense. He was not obstructing. The time frame is not dictated by their manual for administrative stops. It is what is reasonable in the mind of the person who is supposed to have intentionally obstructed. I would ask that all these charges be, or this charge be dismissed, Your Honor.
Your Honor, it's clear that the defendant had the weapon, and it's clear that police officers have weapons. However, it's not clear that there was any fear involved, except for the very calculated, calm expressions on the recording. As I asked Deputy Bindley, no weapons were drawn, no guns were drawn during the contact made with the defendant. In fact, the only weapon involved in this case was the gun that was in the defendant's possession and was obtained and quickly removed from the situation for everybody's safety. Now, as Deputy Bindley indicated, once he was aware that there was a gun, he was concerned because of the defendant's behavior. He didn't want to get shot. The fact that the defendant had a weapon, we're being asked to believe, makes it reasonable that he was in fear for his life when he approached the DUI checkpoint. And I would submit that the only reason that there was any conflict with the officers was because of his failure to comply with the lawful order to roll down his window and the consistent refusal to roll down that window for several minutes. Now, defense counsel repeatedly states that there were 10 officers. When the defendant first approached the checkpoint, there was one officer. And the one officer was asking him to roll down his window. At that point, there's no rational basis to believe the argument, and there are no facts in evidence to support that the defendant was in fear. There are statements that he makes on the recording, but there is no basis to believe that there was any fear that was reasonable. He was the one who was instigating the whole situation by not complying with the officer's order. And defense counsel's argument also fast forwards us to a later time in the encounter and glosses over the beginning of the encounter. And it's simply one officer asking one driver to roll down the window so that he could conduct the brief encounter and move it along. That's all it was. There weren't 10 officers at that point. There wasn't anybody there but Deputy Bindley, who asked him to roll down his window. So to describe that as he is in fear for his life, and when he escalated the situation, it still doesn't support him saying that he was in fear for his life, but the argument being made that he was in fear for his life, because none of the officers removed their weapons from their holsters, none of them pointed it at them. It doesn't fit the facts. It doesn't fit the defendant's recording of the facts. And defense counsel is also arguing that it's a matter of timing. And she indicated this happened in 4 to 5 minutes. If we were to sit here for 4 to 5 minutes, and I know none of us has the patience to do that, we would know that 4 to 5 minutes is long enough to roll your window down. It basically takes a couple of seconds. Not, if I'm not right, 240 to 30 seconds, 300 seconds. It's a couple of seconds to roll down the window. And he didn't do it, because you can tell from his recording, he didn't plan on doing it. He wanted to obstruct. Now here's what I want to clarify as far as the intent aspect of the obstructing law. It is a general intent crime. It is not a specific intent crime. So all he has to intend are his actions. He doesn't have to intend to bring the entire DUI checkpoint to a screeching halt and cause a bunch of chaos. All he has to intend is to not comply. All he has to intend is not moving his hand over to the button to roll down his window. That's all he has to intend. Just like in the case where you're running, all you have to do is intend that you're running. In the case where you're resisting being handcuffed, all you have to do is intend to keep your hands out of those handcuffs. It's a general intent crime, not specific. And Your Honor, I'm just going to point out for the last time that it was not a couple, 3 times that he was asked to roll down his window. We heard on the recording how many times it was, as Deputy Finley testified, at least 10 times. He indicated 10 to 20. If we go with a lower number, 10, it's significantly more than a couple, 3 times. And I'll submit it, Your Honor.
All right, I thank counsel and the witnesses. The matter has been explicated very well this afternoon. Is there any remaining question about this photo from identified as defense exhibit A, but not yet in addition?
No.
Okay. All right. I have reviewed the trial brief that was submitted before the proceeding today, and will address those issues in the ruling which I'm prepared to make at this time.
I'm sorry, can I address that brief?
Address what?
It says that certain statements that are made in the brief are not facts that are in evidence.
I'm addressing any legal conclusions springing from the brief. As I said before, the factual assertions in the brief are those that would typically be included in a pretrial brief and viewed as supportive of the offering party and accepted only to that extent. The legal conclusions are relatively brief, but go ahead and address them.
Your Honor, I just wanted to make it clear that, do you want to go through each of the statements?
I don't believe it's necessary.
I don't either, I just wanted to put that
I
on
think
the record.
any factual matters have been listed at trial, which would support or countervailing factual assertions in the brief, and the legal conclusions have been addressed by both parties in final argument. All right. The ruling regarding the tape will stand. I recognize that the defense has renewed the objection. It was offered and accepted, admitted solely for limited purposes, which were supportive of the deputy's testimony, which I find it was, and remains admitted for that purpose. It did not independently establish any additional facts. As far as a warrantless search is concerned, the initial stages of any search or seizure began pursuant to a lawful checkpoint and merged thereafter into a search and or seizure incident to a lawful stop and arrest. So that motion to dismiss based on warrantless search is denied as well. I've been apprised by one of the court marshals, Ms. Hearn, that your client may be recording this proceeding today. Some courts would not allow that. I do not find it objectionable, but I would caution defendant that any use of that recording, which is contrary to the official recording being conducted as we speak and has been throughout the trial, any use of that which is demeaning to the jurisdiction or decorum of this court could result in a finding of contempt. The ruling of the court today is that Mr. is found guilty beyond reasonable doubt. Treating the reasons not necessarily in order of priority or sequence, which happens when the court rules from the bench. I find no significant irregularities in the checkpoint process or procedure as an initial matter. I find that this is supported by the deputy's testimony as well as the recording, which is simply supporting of the testimony, as I said, that the orders, beginning with the order to open the window and subsequent orders were repeatedly given, repeatedly answered, the same questions, same objections raised by defendant, the same answers repeatedly given and need not have been repeatedly given. There was partial compliance, reluctantly. I don't believe there was ever complete compliance with the orders. Certainly not in any of the critical initial stages. The extent to which did not comply with the orders is illustrated, I think, probably most pointedly by his refusal to even give his name, let alone any other substantive compliance. His supposed fear about the firearm, I find incredibly ironic as a justification for not submitting to a lawful checkpoint, let alone what thereafter followed because of his own conduct. If that's the cause of, if that's the justification for non-compliance, then perhaps the defendant should consider not carrying a firearm, whether lawful or not. The observation by Officer Atkins of a magazine, I think changes the non-compliance to a different magnitude. The initial compliance of repeated failure to do such a simple thing as open the window, and that occurred before the vehicle was off, and after the vehicle was off, as well when Mr. could have even asked, I suppose, to start up the vehicle again to reinitiate the automatic windows. The dinging bell is instructive, but maybe not conclusive on the tape, that it indicates either two things or both. That is, that a seatbelt is disengaged, giving further reason why he could not have complied, and or that the key was in a position which indicated that he still retained some control of the vehicle. So there was that initial phase of complete non-compliance, repeated identical questions, repeated identical answers, and then the observation of the ammunition magazine, as I said, kicks this up to a completely different level and justifies what the officers did thereafter. Sensing that a weapon might be present, and of course indeed finding a weapon, and justifying the reaction, I might say the same kind of fear that allegedly was thereafter fully justified by the officers in fear of their own safety. Any confusion regarding this incident, I think, is demonstrably the result of the defendant's failure to comply with what the officers said on the tape, some very, very simple orders and requirements, which could have extricated the assertion was made, not proven, as a matter of evidence, because not necessary for today's purposes, that he was not intoxicated. All the more reason why, perhaps, if that be true, why compliance should not have been forthrightly exhibited. His repeated questions about the lawfulness of the matter, as Ms. Hearn pointed out, is justifiable to a certain extent. But again, having been repeatedly answered, and not the time for officers to start providing extended legal advice to this or any other defendant, there comes a point when compliance is required and not a legal discussion, particularly under those circumstances, advanced as they were after the discovery of the weapon. Very clear what he needed to do. There may have been numerous officers on the scene, and there may have even been more than a couple of them shouting orders, again caused by his non-compliance. I think what he needed to do was abundantly clear, regardless of several voices having been telling him to do exactly the same thing, I would note. And again, any reason for his fear was largely a result of a misapprehension of what was going on, an unjustifiable misapprehension as well as his own conduct from the very beginning. I find that, in fact, that the officers exhibited almost astonishing patience rather than any rash action. So for those reasons, the ruling has, as just indicated, found guilty beyond a reasonable doubt. I would just indicate that Ms. Hearn massaged this matter about as well as could possibly have been done. She can only work with the evidence that she's presented. So I thank the parties again for their presentations, and that is the ruling. Mr. Rango?
Your Honor, with regard to sentencing, first I will mention that I believe that Mr. has no prior criminal history. And in addition to what we've talked about for quite some time today, I will express a concern with regard to the defendant's very direct opposition to the police officers. I think the recording itself, the YouTube recording, that a couple of weeks, it was viewed a couple of weeks after the incident, and it was subsequently removed from YouTube, and I don't know who did that. But I will say I am concerned about what appears to be a very direct, intentional decision to kind of confront the officers. In this case, this happened to be Deputy Finley. But I think it's clear, and I'll leave it to the court to make its own determination, but I think it's very clear that it was an intentional act. That we don't have just an obstructing that just happened under the circumstances. Whether or not it was a circumstance of opportunity, or, hey, I'm going to go through this checkpoint and I'm going to go find it, I'm going to be there, and I'm going to do this. I don't think I'll ever know, but my suspicions are very close to that. Like I said, he has no prior criminal history. This case is from December of 2010. That's what we've been talking about all afternoon. But I do have those concerns, and it's an officer safety concern. I'm going to ask for 6 months in the Washoe County Jail. I am going to ask for that to be suspended. And like I said, no prior history, and this case is quite old at this point. But I'm going to ask for a $1,000 fine, not suspended, that he obey all laws. I'm also going to ask, in addition, for 48 hours of community service. And I'm also going to ask in this case for anger management. It's not often a recommendation that I make an obstructing charge, but in this case, I don't know what was going on here and why there was what appears to me, a direct, a very directed, intentional contact with the police officers that you heard on the video recording and was placed on YouTube. I've actually never had an obstructing case like this. I've had very few cases that show this kind of direct intent. Those are usually reserved for stalking cases. It does bring to mind psychological evaluations, but I think at this point, requiring him to do community service, pay a fine, and complete anger management, I think should suffice. And I do want to thank all the officers, especially the ones that did testify, for being here today.
And I'm sorry, I didn't hear what the community service was.
Coming down.
Your Honor, I would speak to this in that this is the third time that this defendant had been stopped by a DUI checkpoint. And needless to say, his frustration had grown with regard to it. And partly because he doesn't drink, and partly because of his complexion, he's always accused of being reddened or having bloodshot eyes, and he does wear contact lenses. Now, he certainly has been through a very frustrating experience, and the time before this, the police officers had said to him, "We don't want to see you around here anymore." He lives in the area where they tend to have these roadblocks, these administrative roadblocks. The other thing is he's been, at 42 years old, he's a skilled marksman. He's been involved in going around the country, being involved in shows or contests or whatever where you do marksmanship and so on. He certainly had experience with how police overreact to persons who are involved with firearms. So, Your Honor, again, I would ask that whatever sentence be imposed certainly be considered. He does not have an anger management problem. He's just frustrated in that he's always being stopped because of their tendency to put them, as the officer testified to, in places where they're going to pick up more people who tend to be intoxicated in that area, and that happens to be in the area where he lives. And there's no issue with obeying all laws. He has no priors, Your Honor, at all. At all. Nothing. And so I believe that the fine is excessive. The 6 months in jail suspended is excessive. It should not be more than 30 days. And that he should not have to attend anger management, Your Honor.
All right, the order is going to be 45 days suspended for a year, obedience to all laws, 40 hours of community service, plus assessments. There will be a requirement of the mini anger management class. I believe that's available at ACCS, most effectively as other places.
What do you call it?
Your Honor, you're referring to the 14-week anger management?
Yeah.
The mini is the domestic violence, so it's just 14 weeks.
Right,
Is that your
I would
intention?
have called the mini anger management class also, but I guess it's not necessary. In any event, it is the 14-week anger management class. I'm doing this because it is your record otherwise appears to be clear, and because this case is now a year and a half old, during which time you've been compliant with the law apparently. But I have to concur based on the testimony from both sides that this was a rather serious incident. And everybody's rather fortunate that it wasn't considerably more serious. This thing could have spiraled out of control in a New York minute, and everybody would have been in serious danger, if not worse. there is an apparent anger problem here. Contact with officers. I can sympathize with having gone through 3 DUI checkpoints, even though I've never been through one in my life. I've lived here for 30 plus years, but in any event, this is not good behavior, and particularly if you're packed in a weapon. This could cause you some very serious problems, let alone officers or anybody else. So those are the requirements. And if you still have time, or you can come back tomorrow if necessary to sign up outside. All right, thanks everybody.